Facebook, YouTube, Twitter. Names that have been added to our pop culture vocabulary in recent years. And for millions of people worldwide, posting to the social networking sites has become a part of their daily routine. And that is getting the attention of employers. A recent survey by internet security firm Proofpoint found that 45% of employers are highly concerned about unauthorized information being posted on social networks, and 8% dismissed employees for social media misuse.
The potential for disclosure of company information, including some things that might be confidential, things the employer does not want to publish to the world.
Labor and employment law attorney Justin Flam of Taft, Stettinius, and Hollister in Cincinnati says it can also be a matter of corporate image, as was the case in a blog written by an airline employee.
When she posted some pictures of herself in her uniform with a rather revealing top, the airline decided that it did not like the way it was being presented to the public, to all the people who were viewing that blog, and it ultimately ended up terminating her employment.
With more than 33,000 employees and thousands more agents, Nationwide Insurance is evolving its policies to stay ahead of employees' use of social networking both at work and at home.
We expect you to not be harassing other individuals, not to be discriminating against anyone, really basic there, but also not to be disclosing company confidential information inappropriately, also not to be disparaging others or to be disparaging the company.
Steve Keyes, Vice President for Associate Relations and Human Resources Policy, says Nationwide also wants to make sure that it's not missing out on a golden opportunity to leverage this new media.
We want to enable our employees and our company generally to be leveraging the power of social networking channels or social networking media, and enable our employees to be brand ambassadors if that's part of their job or just if that's something they're comfortable doing.
Charles Schneider is the administrative judge for the Franklin County Common Pleas Court, where non-work-related email and internet usage is supposed to be kept to a minimum.
You know, regarding the use of any of the technology we have on work hours, it's primarily for work purposes. I mean, we're here to do the work of the taxpayers of the court, and they expect us to be working.
And have there been any discipline problems where you've had to take any type of action?
Yes, significant problems that have resulted in significant discipline up to and including termination. In what people are posting or what they're receiving and saving or sending, it's stunning that anybody would think this is okay.
So how can an employer restrict an employee's free speech rights? Well, Flam says there is a misconception about First Amendment rights.
The First Amendment applies to the government. So if you work for a private employer, as most people do, there is no First Amendment right that affects your workplace. If you work for a public employer, such as a public university or a sheriff's department, for example, there is some limited protection that you get from the First Amendment, but it is limited. And if your comments are going to cause a disruption in the workplace, or if they're defamatory, then you may still lose your job despite the First Amendment.
For the Ohio State Bar Association, I'm Stephanie Bucher.